A political and legal earthquake shook Washington this morning after a federal court ruling triggered what many observers are already calling one of the most serious constitutional confrontations in modern American history. The decision arrived without warning, but its impact was immediate. Within minutes, financial markets reacted, government officials scrambled behind closed doors, and legal analysts across the country began debating what could become a defining test of presidential authority and judicial power. The ruling was not a recommendation. It was not a suggestion. It was not a strongly worded criticism wrapped in legal language. It was a direct federal court order that challenged the scope of executive authority in a way that few believed possible. The moment the decision became public, every major institution in Washington understood that the situation had moved beyond ordinary political conflict and into entirely new territory. The path to this moment did not begin today. It began weeks earlier with what initially appeared to be a routine oversight dispute. Congressional investigators requested documents related to the use of emergency executive powers. Such requests are common in Washington. Most are resolved through negotiations between lawmakers and the White House. Sometimes documents are released. Sometimes compromises are reached. Occasionally disputes make their way into court. This time was different. The requests were rejected. Congressional subpoenas followed. Those subpoenas were challenged. Court orders were issued. Appeals were filed. Each stage pushed the conflict further. What might have been settled through cooperation instead evolved into a prolonged legal battle that steadily increased the stakes for everyone involved. As deadlines approached, tensions rose. Rather than moving toward compliance, both sides hardened their positions. Legal arguments became constitutional arguments. Procedural disagreements transformed into questions about the limits of presidential authority. What had started as a dispute over records gradually became a confrontation over the balance of power itself. By the time the court ruling arrived this morning, the machinery of conflict was already in motion. The court's decision immediately sent shockwaves through Washington because it addressed far more than a document dispute. At its core, the ruling challenged the relationship between the executive branch and the judiciary. It raised questions that constitutional scholars have debated for generations, but that have rarely been tested under circumstances this dramatic. Can a court compel a president to comply with its orders? What happens when a president refuses? Where does judicial authority end and executive authority begin? Those questions suddenly moved from academic discussion into political reality. The response was swift. White House officials quickly condemned the ruling, arguing that it represented a dangerous expansion of judicial power. Congressional leaders from both parties held emergency discussions to assess the implications. Legal experts appeared across television networks offering sharply different interpretations of what the ruling meant and where it might lead. Meanwhile, investors reacted to the uncertainty. Markets dislike instability, and few things create instability faster than a constitutional confrontation involving competing branches of government. As traders attempted to assess the potential consequences, volatility spread through financial markets. Yet beneath the headlines, a deeper struggle was emerging. This is no longer simply a dispute about documents, subpoenas, or legal procedure. It is becoming a test of institutional authority. Courts derive their power from the expectation that their orders will be followed. Presidents derive their authority from constitutional powers granted to the executive branch. The system functions when those powers coexist within accepted boundaries. The challenge arises when those boundaries are disputed. Throughout American history, moments of tension between branches of government have occurred repeatedly. Courts have challenged presidents. Presidents have criticized courts. Congress has intervened when conflicts became too severe. Yet the system has generally relied upon a shared commitment to constitutional norms and institutional respect. That shared commitment is now under intense scrutiny. Supporters of the court argue that no individual, regardless of office, can stand above the law. They contend that judicial orders must be obeyed because the rule of law depends upon compliance. In their view, allowing any president to ignore lawful court decisions would undermine the constitutional framework itself. Supporters of the executive branch offer a different perspective. They argue that federal judges possess significant authority but that certain presidential powers exist beyond direct judicial control. They warn that permitting courts to interfere too deeply in executive functions could upset the constitutional separation of powers and create dangerous precedents for future administrations. Both arguments draw upon legitimate constitutional concerns. That is what makes this confrontation so significant. This is not merely a political disagreement between rival parties. It is a dispute over how power is distributed within the American system of government. The outcome could influence future presidents, future courts, and future Congresses long after the current conflict has ended. At this moment, three separate forces are moving simultaneously. The judiciary is attempting to enforce its authority through legal rulings and procedural mechanisms. Congress is evaluating its options while balancing political realities against constitutional responsibilities. The executive branch is defending its position while challenging the legitimacy of judicial intervention. Each action taken by one branch affects the calculations of the others. If courts press forward aggressively, political pressure on Congress may increase. If Congress becomes more involved, the legal dispute could evolve into a broader constitutional struggle. If the executive branch maintains its resistance, questions about enforcement and institutional legitimacy will become increasingly difficult to ignore. What makes the situation especially remarkable is the speed at which events are unfolding. Developments that might normally take months are occurring within days. Decisions made behind closed doors are producing immediate public consequences. Statements issued in the morning are reshaping political calculations by the afternoon. Washington thrives on uncertainty, but even seasoned political observers acknowledge that this situation is unusual. The stakes extend beyond the individuals currently involved. Future presidents are watching because the outcome may define the limits of executive power. Future lawmakers are watching because congressional authority could be strengthened or weakened depending on how events unfold. Future judges are watching because the judiciary's ability to enforce its decisions may be tested in ways not seen for generations. At its heart, this confrontation asks a simple but profound question. When institutions disagree about the limits of their own authority, who decides? The answer has never been entirely clear because the American constitutional system was designed around competing powers rather than absolute control. The founders expected conflict. They expected disagreement. They created a system in which ambition would check ambition and power would balance power. What they could not predict was how those conflicts would unfold in every future circumstance. That is why this moment feels so consequential. The coming days will reveal whether compromise remains possible or whether the confrontation continues to escalate. Every statement, every court filing, every congressional meeting will be examined for signs of what happens next. For now, one fact is undeniable. A dispute that began with a routine request for information has evolved into a nationwide debate about presidential power, judicial authority, and the future of constitutional governance. Whatever happens next, the events set in motion this morning are likely to be studied, debated, and remembered for years to come.